Hi everyone, this is Veronica. Today, our topic of discussion is fear of executive courts. So, the concept of courts in our country is of constitutional courts and not the executive courts, but are we heading towards executive courts? So, this is the topic of discussion. For my video updates, you can follow me on Instagram. For the PDF of this lecture, it will be uploaded on my Facebook profile. So, if you're preparing for any government exam, our pen drive and tablet courses are also available. For additional information, you can visit our website or you can call on these numbers given on the screen. So this is for your information. All my video lectures are available. Explanation of this lecture are available in Hindi and in English in both the languages. So what is the relevance of this topic according to in your exams? For objective level, judicial independence is very important. In statements it can be asked, and in subjective level, overreaching spelling mistake. Okay, overreaching judicial activism and its consequences is very important. Now, what is the context of today's lecture? If we talk about opinionated judiciary. So, if recently you have seen that Justice S.R. Sen of Meghalaya High Court, he has recently observed in a judgment that he stated that anybody who will oppose Indian laws and the constitution cannot be considered as citizen of the country. So this is his statement. Now he thought to further note that in 1947, India should have been declared Hindu country. This is his statement. And that our beloved Prime Minister ought to legislate to grant automatic citizenship to non-Muslims religious minorities who have come from Pakistan, Bangladesh and Afghanistan. This is what he said. And Justice Sen's ill-advised and ill-judged diatribe is only the latest in a series of instances where judges have inserted themselves into fraught of political controversies and have deployed the prestige of judicial office to lend weight to one side of controversy. So you have seen recently many such examples where judges have stated such interrogated statements. Now, what is the meaning of judicial independence? What does judicial independence entail? We will discuss that, because normally, see, what we think about judicial independence, this is the independence of judges from the government. This is the normal notion. Now, our constitution is designed to ensure that judges can work independent of government influence. How they can work independent of government influence? When they have fixed salaries, they have security of tenure and an appointments process that through the Supreme Court judgments is insulated from executive control. This is how they are independent from the government. Now, independence, however, means something more. This is not just independence from the government. It also requires the judges to perform their constitutional duty. They have to maintain their constitutional role that should be independent of personal biases, their personal political influences and moral beliefs and their partisan ideologies. So this has something more to the independence of judges. Of course, education is a political task, and there is no doubt that a judge's political vision will inform her work, but that does not authorize the judge to turn into a politician, right? So at all times, the judge is bound to maintain primary fidelity to the law, to the constitution of a country, to the text of legal instruments, to the canons of legal interpretation, and to the body of judicial precedent that holds the field. So judicial independence therefore depends on judges recognizing the law as supreme while being influenced by politics is not reducible to it. So that means a judge should stick to the constitution and not to his personal influences, personal opinions. That is what the extended meaning of independence of judiciary means. Now, there is a need of accountability in our country for the judges, for the judicial processes. Now, see, law and adjudication must remain autonomous from partisan politics. This is very important, that the personal opinions should not be reflected in a judge's whenever he hears a case, or whenever he renounces anything when he is judging a case. So the more we strengthen this judicial independence in the first sense, independence from the government, the more attention we must pay to independence in the second sense. So what is the second sense? The personal opinion of the judges, whether they are influenced, whether they like the government or they don't like the government, whether they like opposition or what, their personal biases should be remain apart from their work. Now this is because control brings within the accountability. See, politicians, for example, they remain accountable to the people in at least some sense, because after 5 years elections are held, because they depend upon them in order to continue in office after 5 years. Now these judges who are insulated from any external control are accountable only to themselves. So judges are accountable only to themselves. So this is a very weak form of accountability. Accountability only to oneself, however, is very weak form of constraint. Now the temptation to overstep is always immense, and more so when such immense power has been placed in one's own hands. So therefore in our country the need of accountability for the judges is very necessary. Now we'll see that how this crisis has deepened in our country. So we'll take you to 1980s. There was a rapid expansion of judicial power. This expansion was motivated by a sense that the judiciary had long been a conservative institution taking the side of landed interest against the people. This needed to change. Now, in order to accomplish this, the Supreme Court began to dispense with procedural checks upon its powers. Now, some of these steps were very important and very necessary, such as public interest cases to be filed on the behalf of those who were unable to access the courts. This was very good step by the court at that time. But there were many others which were double-edged swords, such as they diluted the evidentiary standards required to prove disputed facts, and vastly expanding the court's discretion to shape the fashion remedies. So if a judge is biased, this thing is very dangerous in a democracy. And by 1990s and 2000s, under the misleading label of judicial activism, the court was beginning to engage in a host of administrative activities. What kind of administrative activities? Now the judges were telling how to manage welfare schemes. Now the judges were telling how to beautify the cities, and they were overseeing anti-corruption initiatives. So basically this is the work of government, this is the work of legislation, not of the judges. So the constitutional courts had become a supreme administrative courts. They were becoming supreme administrative courts. Now combination of viewing the judiciary as a solution to all social problems and viewing procedure that would otherwise constrain judicial power. So some of these decisions by the judges may seem upright, but the problem here is these works do not belong to the judiciary. These belongs to the government, the legislative people, right? So towards the executive courts. Now see, there are the few judgments like national anthem order. Then there is Tirukural order, that every student in Tamil Nadu must study Tirukural. Tirukural is a Tamil text. Then the NRC process. So even the Justice Sen's recent foray raise an altogether that our courts are going towards executive courts. So all the examples of the judgments I gave you. So here the question is not whether they are right judgments or they are the wrong judgments. The question is, this work, this domain is not of our courts. This domain belongs to the government. So an executive court. So basically who is an executive court? So this is a court whose moral and political compass finds itself in alignment with the government of the day, and one that has no compunctions in navigating only according to the compass. So instead of checking and limiting government power, an executive court find itself marching in lockstep with the government. Lockstep means what government is doing, they will criticize it, they will change it. So they are locking their steps with government. So this is not what a court does in a democracy. So this is not what a constitutional court is meant to do. So what is the way forward? See, we urgently need to return to a thriving legal culture, one that uncompromisingly calls out political posturing. We should have a legal culture where we know the role of our three tiers, right? What parliament has to do, what the legislation has to do, what judiciary has to do, what executive has to do. So as you know, there are three tiers. One is legislation, other is judiciary, other is executive. So they should remain separate. They should remain independent of each other. But here judiciary is trying to lock step with the government, and that is not wrong. We have to maintain a legal culture in our country, and only a principled consistency is requiring that judges must always give reasons. So how the accountability will come in our judiciary, that judges need to give reasons for their judgments. If they have given they have announced a particular judgment, there should be proper reasons for it. That is how the self accountability will be strengthened, which is already a very weak in a very weak way it is shown in our country. So this is the possible way forward, and if you know more, you can write in the comment box. So question for you is, India urgently needs the return of a thriving legal culture that uncompromisingly calls out a political posturing. Critically examine the statement. So you can write the answer, practice the answer. For the PDF will be uploaded on my Telegram and Facebook both. Thank you.